Greetings. I'm OBDK Kamau, and I'm the Associate Director of the Library at Texas Southern University. I have the pleasure this evening of interviewing Mr. Thomas Burrell of the Black Farmers and Agricultural Association. Mr. Burrell, first of all, welcome to TSU TV.
Thank you, Brother OBDK. Thank you for having us on the show.
It's my pleasure. What I really want to do, I believe that the message that you have is very, very urgent and very significant. And I've been going over in my mind about where to start, because this is such a deep historical situation. And so what I want to do is I want to just start with the lawsuit, the first Pickford lawsuit. I would like for you to explain what's involved in that, and then we can just follow the evolution of the various lawsuits, because it has spawned four additional ones.
Yes.
So can you tell us what Pickford 1 is, and let's start right there.
Pickford 1 is a class action lawsuit, and it was, the original complaint was filed by several African American farmers, and they were alleging that the United States Department of Agriculture had violated their civil rights, had discriminated against them by denying them loan and credit benefits.
Explain real quickly why the concept of credit is so important in this action that we'll be discussing.
Well, credit is important because we are not only a democracy, but we believe in economic development. This country is a beacon of economic opportunities. And in order for a person to take advantage of economic development opportunities, as the legislators said in 1866, after we were freed from slavery in the 13th Amendment, in 1865, Congress came back and said that simply freeing a person does no good if they are not allowed to be able to contract.
Okay.
Economic development, if you want to leave something for your children's children, then you have to be able to contract. Wealth is stored up in contracts.
Okay.
Property, bank accounts, insurance policies, etc. These are all bastions or avenues or vault of economic development and wealth. Contracting then is essential for that. Well, so African Americans did not have the right to contract during slavery.
Okay.
And simply freeing them without giving them the benefit to enter into contracts was not necessarily what all citizens had. So in 1866, Congress passed the Civil Rights Act. And that Civil Rights Act basically is what we know today, the beginning of the Civil Rights Movement.
Okay.
But in 1866, the act had nothing to do with accommodation, sitting next to someone. The act said every citizen, every person in every state and every territory had the same right to sue, to be a party, to give evidence for the protection of person and property as is enjoyed by white citizens. That's a contract right.
Okay.
And sometimes I'll use the analogy. The difference between a homeless person and Bill Gates, if we use Bill Gates as a standard of wealth, is the homeless person, for whatever reason, is not contracting with anybody. Bill Gates is wealthy not because there are more hours in the day, but because he enters into contracts, or by virtue of people buying his products. I'm from a city, Memphis, Tennessee, where we have a man by the name of Fred Smith, who owns Federal Express. Fred Smith is a wealthy individual because every time you send a package through Federal Express, you are entering into a contract with Fred Smith.
So
the homeless person didn't enter into a contract. So the inability of not contracting will determine whether or not you're going into poverty and homelessness or prosperity and wealth. That's why people come to this country from foreign countries, because we will give them the right to contract. And contracting then will take away from or dissipate or mitigate any other disadvantages by race or sex that that person might have.
And I don't want to get too hung up on this, but it sounds as if you can enter into contracts almost unconsciously or certainly unaware of.
Precisely. Everything that you have on, everything that you have in your house, everything that you, when you open up your cupboard, you open your refrigerator, That item is there because you contracted. You went into a store. You went to a supermarket. The homeless person, the reason he is homeless, he can't contract for a place to live. He can't contract for food. Now, the question is, are you contracting with somebody else? Because wealth requires that you then get a contract from them. Okay. Now, African Americans, after 1865 and 1866, we then were able to contract, and we were able to acquire over 16 million acres of land. We could not read, we could not write, ebonically speaking, we didn't know where our college, no pun intended, or university was at. But we were allowed to contract. We used our natural talents. We were farmers, we were growers, we were producers. Now we can contract, therefore we were growing for the master, as it were. Mm-hmm. Now we can contract for ourselves, and within 45 years after slavery, Brother Kamal, we purchased more land, or our ancestors, our grandparents, per capita than we own today, all because they could contract.
And they realized.
And they realized. So we do it intuitively. But more than anything, the difference that separates this country from a socialist country is we encourage contracting.
Okay.
People who make widgets in Korea, who make widgets in other places, now they may not be able to contract with those widgets for their own self-purposes and self-determination. Mm-hmm. But here, whatever trade you have, whatever commodity you produce, whatever service you produce, you bring that to this country, we will allow you to contract with that without the restrictions that other countries may impose, and therefore people are are eligible and capable of creating wealth and leaving prosperity for their posterity, which is their children's children.
Okay, so Mr. Pickford and several other farmers allege that the government, the U.S. Department of Agriculture in particular,
yes,
were denying
them the right to contract for credit.
Okay.
Because contracting for money, a bank loan is a contract right. Because I can't get the car, which is a contract, if I don't get the money. I can't get the house if I can't contract for credit. Credit is fundamental to contracting.
Okay.
And Congress in particular passed a law in 1974 that says, it's called the Equal Credit Opportunity Act.
1974.
1974. Interestingly enough, that law was passed for women.
Okay.
Because when women came out into the workforce, basically, after the 60s, they did not have credit. The credit was in the husband's name. And they could not contract to buy a car. They could not contract to buy an apartment. So Congress passed a law called the Equal Credit Opportunity Act, which is extremely powerful and least understood. And it said that any creditor that discriminates against any applicant during any phase of the application violates this act. Now, this is a black farmers lawsuit, as it's called, but for all intents and purposes, it's not a farming lawsuit. It's a credit and trade lawsuit. African Americans were allowed to engage in commerce and trade in the agricultural industry.
Okay.
However, the Department of Agriculture, which is a banking institution as well.
Okay.
Most of us think of the Department of Agriculture as inspecting food, which they do. They more or less provide food stamps. They do. The Child Nutrition Program, they do. But they also make credit available to corporations, to towns, to cities. And they make credit available to farmers and ranchers. And it is that component of credit that they denied systematically African Americans. And that's what the lawsuit is about. Now, what is interesting, as we said, Brother OBDK, is that this lawsuit, rightly understood, should be required reading for any African American advocacy association, civil rights organization, any African American individual, corporation, organization who is interested in helping our people to achieve financial independence should know. It is a must to understand how that act works.
This is Pickford 1.
Now, this is the statute.
The statute.
The law
of 1974.
No, that's 74 statute.
Yes, sir.
Because Pickford 1 used that statute.
Okay.
because that statute applies to the federal government as well. No creditor is exempt from that statute. SB 8 is not exempt. The local banks are not exempt. Credit card companies are not exempt. Ford Motor Company is not exempt. All of the ills that we may have that may, the accumulative effect of denying our community, whether it's in farming or in the urban area, denying us construction loans, denying us loans to open up hair and care and beauty salons, denying us the opportunity to have service stations, denying us the opportunity to do what other ethnic groups are doing.
Yes.
Those are all in violation of that statute.
You know, and what you're saying is so much larger than this specific situation that we're discussing.
Precisely. And that's one of the points we want to make. Because think about it. And I'm not anti-government. I defended this country, or helped to, at least when I wore a younger man's clothes in a little place called South Vietnam.
Okay.
I'm not anti-government. However, the government did admit that it violated our constitutional rights by denying black farmers, black sharecroppers, and landowners the opportunity for credit. And when they did that, Congress did something that it had never done in the history of this country. Because of the severity of this act, the fact that it is being perpetrated against the citizenry by the United States government. In civil rights in time past, there were Jim Crow laws, there were black codes. We sued this bus line, we sued Woolworth for lunch counters, we sued XYZ Corporation. We didn't have to sue the federal government.
Right.
Back then, the government was the agency, the entity that we depended on. We sought refuge.
Yes.
Okay? However, now the government itself is the perpetrator. And that's what makes this so unacceptable, so egregious. So Congress said, here's what we will do. We're going to do two things we've never ever done before. We're going to toll the statute of limitation.
What does that mean?
Tolling the statute of limitation, T-O-L-L-I-N-G. We're going to, because this statute, this law in 1974, has a 2-year window, meaning if someone violates your constitutional rights, you'll have to take them to court within 2 years.
Okay.
But because the acts of discrimination had happened so long ago, and to the extent that the farmers filed a complaint in 97,
okay,
they would have only been able to go back to 1995,
yes,
where most of the acts had already been perpetrated against them. So Congress said, we're going to relax that rule. We're going to toll it so you can file a claim all the way back to 1981. The second thing they did, which had never been done in this country, is they allowed the courts, the federal courts, to relax what we call the hearsay rule.
That's, and you said it had never been done before. But
that's never been done in the history of this country.
That's almost unheard of. It's just, it's so significant.
It is significant.
Anybody who, I used to watch Perry Mason, and now they have all kind of law
and order, Judge Judy, Judge
right,
Wapner.
Yeah, if they say hearsay,
what somebody else said,
yeah, it's immediately
object.
Yes.
Objection. Now,
so they allowed hearsay.
They relaxed the hearsay rule.
Okay.
For this reason.
Okay.
Because the further you told the statute of limitation on the one hand, the greater the probability is that that person back in 81 may be dead now.
Yes.
Or incapacitated.
Yes.
We're talking about acts that happened 32 years ago. So then, if an heir is to make a meritorious claim of discrimination for what happened to Papa, what happened to Granddaddy, what happened to Mama, Uncle Joe, Aunt Hattie Mae, and if Aunt Hattie Mae, Uncle Joe is deceased or incapacitated, the only way I can file a claim on them is to provide hearsay testimony.
Based on what they told me.
Based on what they said. And that's significant because it brings in the other, shall we say, travesty of justice. Now, heirs then are the individuals who would make that argument. The sons of daughters of the sharecropper, the grandsons of the farmer, the great-granddaughter of the rancher. But they didn't know that they could make that hearsay argument. So by calling the lawsuit the Black Farmers Lawsuit, a lot of individuals then who otherwise could have made a hearsay argument based on what they heard, who now lives in Houston, who lives in Chicago
Los
or
Angeles.
LA,
Yes.
didn't know that they could make an argument on their ancestors or their grandparents.
Yeah, when I heard about the black farmers lawsuit and the fact that the black farmers had won, I was giddy. You know, that was just amazing to me. But of course, it was always presented as the implication was is for people who were farming at that particular time.
Precisely. And that was by design, we argue. And it was just that. And it's reasonable to assume that because we respond to symbols, we respond to phrases. So if you call something the black farmers lawsuit, then it's natural to assume that if I'm not a black farmer. Because who would guess that Congress did something to allow me as an heir to make the claim? Because I'm familiar with hearsay. I can't say what happened to Daddy. Daddy died in '85. So you're telling me in 1999 and 2013, I can say what Daddy told me or what Granddaddy or Grandmama told me? It's natural that that heir would know that. So the question then becomes, what organization? And by the way, when the judge certified this lawsuit, Brother OBDK, he said, the judge did, it is the largest civil rights lawsuit in the history of this country. And it's large because, among other things, of the implication against a government agency, let alone the billions of dollars that were made available, and the potential amount of individuals or the number of individuals that should have been paid. For instance, the state of Alabama has about 35,000 claimants, which probably is not enough. The state of Mississippi has about 35,000 claimants.
Okay.
Texas is larger than Alabama, Mississippi, Tennessee, and let's throw Louisiana combined.
Absolutely.
No pun intended.
Absolutely.
Texas had more black landowners, more black farmers, and by association and derivation, more black heirs.
Yes.
In the city of Houston, in the city of Dallas. Texas or Texans receive the smallest amount of payout than any other state. They received less than 500 payments for the entire state of Texas in 1999. There should have been close to 100,000 claims filed in this state alone.
That's like Juneteenth all over again.
Well, I'll let you. I'm visiting today.
Yeah, we won't go there, but
Right.
but people who are from Texas and who know the story of Juneteenth know that we found out a very significant piece of historical information a couple of years later than everybody else. But anyway, that's another interview. Let's go back to Mr. Pickford and his associates with the largest civil rights lawsuit in the history of this country.
Yes.
Go ahead and finish kind of laying it out for us.
Now, after Mr. Pickford and others filed, they paid out several $1 billion to African American heirs, administrators of heirs, or victims. And it was extremely easy to qualify. The question then becomes, what proof was necessary? Again, to the extent that the defendant, the Department of Agriculture, admitted to this, they admitted to that in the 50 states that they made loans and the 9 territories, to include Guam, Puerto Rico, and the Virgin Islands, that when an African American came in to apply for a loan or to apply for credit, to contract for credit, the employees in those offices discriminated against those African Americans.
It was pervasive.
It was pervasive.
To the point that African Americans who may not have been directly discriminated against perhaps would not have even gone to pursue.
Precisely. And then what was so startling is that they acknowledged that, well, we don't keep records of who we discriminated against. Remember that old phrase, they kind of all look alike?
Yes, sir.
Well, that circled back on them. They also admitted that, and the courts found, of course, that black folk don't keep a discrimination journal. We don't have a discrimination logbook. we are used to being discriminated against.
Absolutely.
So the courts and Congress said, well, how do we solve this problem? The defendant doesn't have documentation. The heir, of course, is not going to have it. So how do we pay these individuals? They allowed that individuals to make a claim based on his or her allegation of discrimination. That is to say, you and I may be the heirs of a black farmer or rancher, then we would simply make the allegation that my daddy said or my grandmother said. They went down to USDA and tried to apply for a loan, and they were denied because USDA was found guilty of not even allowing the African American to apply. Remember that statute. The statute said that any creditor who discriminates against any applicant during any phase, which is ECOA, and it's coded, by the way, or codified or chronicled under 15 USC section 1691. But I'll come back to that a little later.
Okay.
That's where it's written down. Any phase simply means going to the office and asking for an application. And if they even denied you the application, they violated that statute. Therefore, you may have, your father may have gone down to USDA and got a loan.
Okay.
Let's say he got the money, but he may have gotten it late. My father or grandfather went down to USDA and they did not give him a loan.
Okay.
They denied him at the front office. The secretary denied him. He attempted to apply.
Okay.
He would have been entitled to fill out the loan application. That's why most banks today, when you apply for a loan, whether you get the loan or not, they're going to allow you to fill out the document because that's what the statute required. But USDA operated under the good old boy system. And that is to say, well, we may give you the application, we may not, and come back next week, come back next month, don't come back at all, we're out of money, we're out of paperwork, and they would not allow that person to apply. And they violated that statute. Now, let's say your father ran the gauntlet. He got past the secretarial bureaucracy.
Okay.
He talked to the loan officer. The loan officer gave him, say, $50,000.
Okay.
But he gave it to your father late. And your father may, because of it being late, he may have gotten behind for whatever reason.
On his payment.
On his payment.
Yes.
The ECOA statute calls for what is called loan servicing. That is to say, before you liquidate or accelerate that person, which is another way of saying foreclosing, you then have to call that person in and rework that loan, re-amortize that loan, reschedule that loan, write that debt down in a lot of cases, or write the debt off altogether, because farming falls under what is called an entitlement program.
Okay.
Now, I know there's a big controversy there.
But let's hear what it
Okay.
means in this situation.
What it means is the Department of Agriculture and the Department of Defense are entitlement agencies.
Okay.
Let's say that you are McDonnell Douglas and you need to make F-15 jets for the Air Force or the military.
Okay.
And let's also assume that because of budget constraints, then Congress may have not appropriated money to pay for those F-15 jets.
All right.
But the Secretary of Defense entered into the contract.
Okay.
In other words, the government has said, we need a military whether or not it's profitable for McDonnell Douglas. We've got to make sure that McDonnell Douglas survives. We have to make sure that Morton Thiokol survives. We have to make sure that General Dynamics, who makes the tanks, survive, whether they made a profit or not, because war could break out.
At any time.
At any time. Farming falls under that same category. It is a method of defense. In other words, you have to have farmers, whether he made a profit, and I'm not saying that they're not making a profit. What the government says, we need XYZ farmers and ranchers, even though the weather may be bad, even though it could be a drought, even though it may be hard times on the commodity. We need these producers. So they come under the entitlement program. That is to say, if necessary, to keep him or her in the industry, you will write his debt off if necessary.
So
What happened to African Americans, though, they would not write your father's $50,000 debt off.
So even though he had the loan, he still lost his land.
He lost his key phrase, and that's how we lost ours.
Yes.
Most black folk, when I say ours.
Yes.
As I said, in 1910, we had 16 million acres of land. Today, we own less than 2.5 million acres. And they would use that loan to lure you in. Sure, I'll let you have a $50,000 loan, but Mr. Kamal, you have to put your property up as collateral.
And
I'm going to give you the loan in such a way that I know you can't pay it back. And then when you get behind, I will not give you a debt write-off. I won't write your loan off. I will not re-amortize your loan. You know what I'll say to Mr. Kamal? When you know times are hard, you ought to go to Houston and get you a public job, and we're going to foreclose on your land. But with the white farmer, they would write his debt off, give him new operating loans because of it is a GAN
and entitlement. And this is, like I said, this is so large. What you're talking about, the black farmers deal, is huge, but when you start thinking about the fact that we have no convenience stores in our communities, we no longer have gas stations in our communities. Now, some of us did at one time, but all of this government policy can make people migrate. Government policy can have so much impact, and we don't realize how much it impacts our life, and sometimes we don't even participate in the process just based on that ignorance.
There's an old saying that a person will choose according to the alternatives that are made available to them. Therefore, if I take the alternative of survivalship and profitability from you in agriculture, you're going to load up the truck
and go to
and move to Beverly or Houston. Because it's human nature that you're going to feed your family.
Yes.
So if I deny you the opportunity to feed your family, if I deny you the opportunity to produce as a gas station owner, as a hair care producer,
yes,
as an XYZ, as a laundry, as a grocery store, you're going to have to sell that business and do something else. Now, we know somebody has to own a service station in the community.
Absolutely.
We know somebody's going to have a grocery store. We know somebody's going to need a hotel. Here's what we're going to do instead. We will offer this opportunity to another minority. And we will allow him to, quote unquote, contract for credit. And we will deny African Americans in that community the opportunity to contract for credit. And we then become consumers.
Yes.
Let's go back to that original argument.
Yes.
Contracting. Profitability is a function of not only who is contracting with you, but who you contract with. When we contract for a loaf of bread from that local store or buy a gallon of gas, we're using our money to buy his product. He's going to make the profitability.
Yes.
We are then consumers. We are the person priming everybody else's economic development pump.
Yes, sir.
If I might use that analogy.
That's a wonderful analogy. So I have to congratulate Mr. Pickford et al. And you broke it down for us.
The et al.
That et al. Part, that's NIM.
That's
Mama NIM, Uncle Willie NIM.
We don't, attorneys use the phrase et al. That's a Latin term, me and others.
Yeah.
But I tell people when we're holding presentations, we already know what et al. mean. That means NIM. Somebody asks you, hey, how your mama NIM? That means your mama, your father, your uncle, your auntie, everybody else. So in class action lawsuits, they will name one person and put ETL behind it. Timothy C. Pickford et al. But if you look like I look, a little bit to the right, a little bit to the left, you one of the et als or one of the NIMs.
Yes, sir. Okay, so Mr. Pickford filed a suit in 95.
97.
97.
Yes.
And they told the statute of limitations back to 1981.
Yes.
The suit was settled in 1999, if I'm not mistaken.
Yes, 2 years later.
Okay. So exactly, as a result of this suit being settled, Mr. Pickford and other black farmers were able to receive a payment directly
Yes.
from the USDA.
Yes.
Exactly how did that work? It was, for the most part, we heard $50,000 and
Yes.
okay,
The amount of compensation was broken down into what I call 3 segments. Relief. And if we could draw a pie, a relief pie, there was a cash slice,
okay,
there is a debt release slice,
okay,
and there is another slice called injunctive relief.
okay.
Let's go back to your father again.
All right, he got
Let's
the
assume for the sake of
$50,000.
illustration that your father passed away in the early 80s.
Okay,
And you heard about this lawsuit. And you remembered how they gave him a loan, but they did not give him what he needed. They did not give him loan services. And at this particular time, your father has accumulated a debt of $80,000.
okay,
And you're still holding on to that property.
okay,
You then, OBDK, would have been able to file and receive that $50,000 slice.
that's relief.
Now that's cash.
That's cash, okay,
The other slice would have been debt relief. They would have written off whatever debt he owed.
so the $80,000 is
Would
wiped
have been
away,
wiped clean.
Okay.
Therefore, that land now would have been freed up.
and it could be profitable.
It could be profitable again. Then you would have been eligible for that third slice,
Okay,
which is a slice known as injunctive relief.
Well, you
Now,
know I'm
you
gonna
know we
ask
don't
you.
understand what that means.
What does that
I'd
mean?
never heard of it before. It means more money, more relief. Injunctive relief would then be amount of relief to penalize the government for discriminating against you.
Okay.
And making you whole, putting you where you ought to have been, would have been, should have been, but for the discrimination.
okay,
The injunctive relief, then, you would have been eligible, and still would be, for a priority loan to buy more property,
okay,
to buy more equipment,
Yes,
and
sir.
to have that property, shall we say, put in a position, cultivation, terraces, to make it, to groom that property. Today, that could be as much as $3.9 million per claimant. So Brother OBDK could have gotten the $50,000 in cash, daddy's farm cleared or wiped off, and you then would have been eligible for a line of credit to go back in and to buy more land and inventory, etc. We have an example in our organization where a young man was working for a landscape company.
okay,
He worked for a landscape company. They had the tractors, they cut grass, they did all of the landscaping work. He then bought, after he got his $50,000, he went back and got the big money, as we call it, the class-wide injunctive relief. He bought the landscaping company from his boss. He now has about $6 million in contracts. They cut grass on the highway in Tennessee and Kentucky and Mississippi. But more importantly, he employs over 50 African Americans,
that's
all traceable to this black farmers lawsuit. As I said, this lawsuit, rightly understood, can solve a lot of economic development. Now, he didn't have to go back into agriculture. He chose to do something else with his class-wide injunctive relief.
yes,
But he bought his old company out, hired his sons, his nephews, his cousins, and 35 or 40 other individuals. And now I think they have about $6 or $7 million. I know $6 to $7 million in contracts from state agencies, city governments, and municipalities.
How long did that suit last?
That suit lasted from 1999, and it actually closed in 99, which is a controversy.
I can imagine.
Because we then argued, this association went to Congress and argued and lobbied and said that, wait a minute, you only paid X number of African Americans in that first lawsuit, Pickford won. There are still thousands of individuals out there who have not been compensated. So then they opened the lawsuit up again and called it Pickford or In Re Black Farmers, which is the same as Pickford 2.
Okay.
And then other minorities got involved. Native Americans got involved and says, wait a minute, we were discriminated against too. Let's have a lawsuit. Hispanic Americans got involved and said, let's have a lawsuit. And females got involved again and said, let's have a lawsuit. So technically now there are 5 different lawsuits. Pickford closed, and I will use the analogy sometimes as buses.
Okay.
So you may have missed the first bus, which was Pickford 1. Then you had an opportunity to catch the second bus, which was Pickford 2, or the Keep Siegel bus for Native Americans. And the buses that we're talking about right now have been combined. Garcia, the Hispanic lawsuit, has now been combined with the female or women farmers lawsuit. And that lawsuit, or those lawsuits, are going to close on May the 1st.
And this is what is so important. And I don't know if this will even air before May the 1st, but of course we've gotten, got you on the radio so people can hear about this. Now, the Pickford lawsuit 1 is of course very significant because it started this bus line.
This bus line.
The first bus ended, then they opened it up again, but for
Send another bus.
Limited amount of time.
Right.
Then Mr.
Keep Siegel.
For Native Americans came and got another bus.
There was a female Native American. Her name was Marilyn Keep Siegel.
Keep Siegel, okay.
Yeah.
Now,
representing Native Americans. That's the third bus.
Was it possible for black people to be included on Miss Keep Siegel's bus?
Yes.
Go back to that.
As I said, we missed the third bus.
Yeah, so we missed the third bus. And if we didn't think that we fit in under black farmers, we certainly didn't think we fit in under Native American farmers.
If we missed the first bus for us that had our names on it, right, African Americans and black, we probably would have missed Keep Siegel and Garcia and the other lawsuits. You're
Love,
quite right.
I believe it's Love.
Love.
Right. So now black people who are working to catch this bus before May the 1st, the last bus is leaving the station, and you're pretty sure that there won't be another bus coming.
Well, Congressman Al Green was saying this morning he was going to try to make sure another bus, and we're asking our congressional leaders to provide another opportunity.
Wonderful.
Wonderful. Because here again, we have too many African Americans. You now have other ethnic groups who heard about the black farmers lawsuit and they filed suit and they are about to get paid. And you have the sons and daughters of black farmers, the individuals who the lawsuit was designed for, don't even know that the lawsuit exists.
So,
and it can be extended.
It's just a matter of extending it.
And it's a matter of extending. We have not because we ask not.
We ask not. Now, one thing that's very important is that black farmers can now get on
or their heirs,
or their
administrators, or their
assigns, can get on the bus that's currently for Latino, Hispanics, and women.
Yes.
And has that been an issue to get black people here to understand that?
Of course. Because the first thing individuals say, well, I'm not Latino, I'm not Hispanic, and I'm not a female. And I use another analogy when we are making presentations. And if I were to use, here again, Houston, if we were to go down to the local Greyhound bus company to catch a bus from here to Dallas, the bus would probably, the marquee would say Dallas. However, there's a town called Buffalo between here and there. There's a town called Corsicana.
That's my
and there's another town called Fairfield. The marquee on the bus is not going to say Corsicana.
No, sir.
It's not going to say Buffalo.
No.
It's not going to say Fairfield. It's going to say Dallas.
Yes.
Now, if you don't know that it's going through Corsicana, you will be waiting for the bus to say it's Corsicana.
And
it's not going to say Corsicana. It's only going to say Dallas. So my point is, you'll have to know this is the bus that I need to catch, even though the name where I'm going to go is not there. What is interesting about all of these other minority lawsuits is they're all suing the same defendant for exactly the same infraction. You're suing the Department of Agriculture for violating the exact same statute.
Okay.
The Equal Credit Opportunity Act. Now, we have some issues with the fact that the government divided those lawsuits up according to caste, gender, and ethnicity. We believe that is an inherent violation of separate, no matter how equal you try to call it. I thought we solved that problem back in 1954 with Brown versus the Board of Education, where the Supreme Court said, among other things, any process that is separate is automatically suspect, is constitutionally suspect.
Inherently.
But here, inherently. But now we're going to let this government get away with having a water fountain for black farmers, a water fountain for female farmers, and a water fountain for Hispanics. It's something wrong, brother OBDK, with that picture.
Yes.
Why do we have to have 5 different lawsuits? As a matter of fact, Congress did not set aside money for 5 different lawsuits. Congress passed a statute that says any claimant. However, the Department of Agriculture, we believe, acts sometimes above the law. They came back and created these segments.
These different buses.
These different buses for different groups to get paid at different times and to receive different and varying release. Discrimination is inevitable, which is why we believe the Supreme Court said that anything that's separate is inherently unequal. This is a slippery slope.
Let me ask about the Black Farmers Agricultural Association. I appreciate so much the work you all are doing. Would you give us the history of this organization and how did you get on this path?
The Black Farmers and Agriculturalists Association is an advocacy association. We were formed in 2003, advocating again, because every time the government would open up one lawsuit, they would leave thousands of folk out. So we started advocating for the rights of African American farmers and their heirs and their descendants and their administrators. We are partly responsible for the reopening of the second Black Farmers lawsuit, even though it has some flaws and defects as well. But we advocate. We go around the country, as we are doing here, helping individuals to even know about the lawsuit. One of the problems that happened in 1999 is that the notice campaign was left up to the defendant. Again, it was the largest civil rights lawsuit in the history of this country, Brother Kamal. Where were the civil rights organizations?
Do you know? I mean, just out of curiosity, did they just decide it was for farmers? Where were they?
Maybe, and you mentioned the phrase, there was a little Juneteenth in everybody. But here again, the judge said it. It's the largest civil rights lawsuit in the history of this country. We wrote the book on civil rights.
We did.
But for whatever reason, this large lawsuit, this large civil rights lawsuit, did not get picked up and or promoted by the civil rights community. At any rate, therefore, we have to have some association to help get the word out. Most of what African Americans know about this lawsuit, even the ones who know about it, the information is coming from the defendant. Whatever USDA says, that's how they were allowed to separate the lawsuit by caste. That is a fundamental violation of civil rights law. On its face, we should be suspicious of any agency that says, well, I'm going to create these varying schools, a school for black farmers, a school for white farmers, a school for Native Americans, etc., etc. That alone should have raised red flags.
What's the future of the Black Farmers and Agriculturalists Association?
We believe the future is very viable because there are so many other things that need to be done. As I just said, if you don't have an advocacy group, most individuals in other communities, in business or elsewhere, they're going to belong to associations.
Yes.
Associations got their existence, basically their being, when this country was founded. The First Amendment. The framers of the Constitution said, among other things, there will be no legislation regarding religion.
Yes.
We are allowed to engage in free speech. We are allowed to associate.
Yes.
And to petition the government for redress of grievances. Most of our, if we go back to the civil rights achievements that we made in 1954, no political party, it was not the Democrats versus the city of Topeka. It was not the Republicans versus Topeka. It was the NAACP versus,
yes.
basically.
Yes.
Associations have always been the entity or the vehicle that we use to advocate for our rights in court in advance. It's almost hard for an individual to do because the amount of resources that are required.
It's so massive.
The statute that we're using, 15 UFC, the Equal Credit Opportunity Act, is a litigation statute. That is to say, it's a powerful tool, but it'll only work if you're in court.
Okay.
The average person will not have the resources to make that viable tool available to them. You can file a lawsuit in this country basically 3 ways, or represent yourself as pro se, meaning individually, through an attorney or an association.
Okay.
Associations have always been around. And that's why the framers of the Constitution made sure
in the First Amendment
to the Constitution, I think going back, if my civics is correct, September the 17th, 1787.
1787, that's
the
correct.
First Amendment.
And the amendments, of course, dealt with individual rights.
Precisely. But the right to associate, and if you read
and I remember, I just never quite knew what it meant.
That's a powerful concept.
It's very, very powerful.
Because even the framers and the Supreme Court justices acknowledge that political institutions, whether it's whatever political party, may have to represent so many different interests until your community may have a unique interest
that they cannot,
that may be divergent from the whole.
Yes.
Therefore, you will need somebody to represent your Black Farmers and Agriculturalists Association represents the unique interests of African American farmers, landowners, and ranchers.
I would like to ask you something, because this whole concept, and we are so citified, as my grandmother would say, and we don't truly understand our history, and of course there are many reasons for this. Why should Black Americans relate to Black farmers?
Why should they, or why don't they?
Well, first of all, why should they? And then we could talk about why don't they. But why should we relate to Black farmers?
You have 2 good reasons.
Okay.
One is spiritual, the other is economical.
Okay.
The spiritual reason is we were brought here for this country for one thing and one thing only. We worked the fields. We made this country profitable.
Yes, we came here to farm.
Black farmers were slaves.
Yes.
We didn't come here with deeds to property. We were not the president of XYZ Bank. This country was able to buy Louisiana,
yes, sir,
from Napoleon Bonaparte in 1803. Yet this country was only, 25 years old?
25 years
How
old.
does a country, 25, 26 years old, give $15 million to another country that's been around for a millennium?
Yes.
Slave labor. How did we buy the Midwest territory from Great Britain? That is to say, what we call now Ohio, Indiana, Michigan, and Wisconsin.
Yes.
We had slave labor. How did we buy every state in this union? We didn't fight for one state. We purchased every single one
from
to
another
include
colony.
Texas,
yes,
from another colony, from the Spanish, from the British, from the French, and we were flush with cash. Slave labor, sir. This country owes us. Now, that's not a reparation argument.
Okay.
Now, but the point I'm making is we were brought here as slaves. I'm a firm believer that somebody looked up from a sugarcane field 250 years ago, who looked up from a cotton field 250 years ago, and said, not to turn this into a religious.
That's all right, because I believe this. Go right ahead.
God, if you don't do it for us, one day do it for our children.
Our children.
And this lawsuit then is paying us for really discrimination that was perpetrated against them. My point is this, Brother OBDK. If nothing else, we ought to make sure that their labor was not in vain. If we don't do something, if we don't make sure that our ancestors were recognized and compensated and paid for that period of time, which everybody now was saying was a hideous nightmare, then nobody else is going to do it. We owe our ancestors that. The second reason, economics.
Yes, sir. Go ahead.
Agriculture now, they're calling it the Food and Energy Act. Hint, hint.
Yes, sir.
I left the farm in the 60s going, as I say, I studied the 3 R's, reading, writing, and Route 51, northbound lane, to the auto patch.
Okay.
My family migrated to Michigan.
Yeah.
Now we left the farm going to Detroit and General Motors and Ford. Now Ford is looking for somebody to grow corn. Hello, ethanol.
Yes.
Okay? That 10 acres, that 50 acres that you have now is going to become profitable because farming is going to be an alternative source of energy. That's what's driving getting rid of black farmers, if I might add. You bring us here to farm because it was profitable. Now you're going to get rid of us out of farming because it's profitable. Discrimination, sir, is profitable. That's why you almost have to have an association. It was discrimination that brought us here. It's discrimination that's driving us away. But we should be able to partake and share in the proliferation, the superabundance of this new industry calling energy and food. And agriculture is the industry of the future. So we ought to be there. The last thing we ought not to be.
Right up front.
Hello. We ought to be. They brought, as my grandmother would say, Brer Rabbit to the briar patch.
Well, you know something, I have truly enjoyed this interview, and I want you to give some information so people can get in touch with you, can join the Black Farmers Association, and understand how significant this whole situation is. One of the things that you said at one of your information sessions is you talked about our being able to get the Civil Rights Act of 1964 passed and 65 passed and 68 passed, but this suit is the first time any money has come forward.
In other words, we solved the civil rights argument. We solved the Brown versus the Board of Education. We solved the Browder versus Gale against Montgomery, but nobody got a check back then.
Yes, sir.
What makes this lawsuit here again the largest civil rights lawsuit in the history of this country is now you get at a minimum of $50,000 check. That's never been done. We want to make sure, and it's unfortunate, the state of Texas only had a handful of claimants. We're going to try to make sure that as many individuals in this state receive their pro rata share, their share of the blood and sweat and tears to make sure that they are compensated for the admitted wrong that was perpetrated against their ancestors, their mothers, their fathers, and grandfathers in agriculture. If I might give our webpage,
please.
You can go to our website, which is www.mybfaa. That is www.maryyellowbobfrankapple.com. You can call our office. We are a national association, but we are based in Memphis, Tennessee. Our telephone number is 901-522-8880.
Mr. Thomas Burrell of the Black Farmers Agriculturalists and Association, thank you, sir, for a truly enlightening conversation.
Thank you, Brother Kamal. Thank you, sir.